The average nursing home in the United States now costs $9,300 per month. That is $111,600 per year. If you spend 3 years in a nursing home, which is the average stay for someone with dementia, that is $334,800. For a memory care facility, the national average is $11,200 per month. 3 years in memory care will cost your family $3,200. And here is what most people do not know. Medicaid, the government program that pays nursing home bills for people who run out of money, has a trap built into its rules that catches families off guard every single day. It is called the 5-year lookback. If you gave money away, transferred your house to your kids, or wrote large checks to grandchildren in the 5 years before you apply for Medicaid, the government will look at every transaction, every gift, every transfer, and it will calculate a penalty period, a stretch of time during which you are ineligible for Medicaid, even if you have no money left to pay the nursing home. Families who gave away assets to protect them discover, too late, that the transfer triggered a penalty that leaves their loved one with no money and no coverage. This episode is about how to protect your home and your savings from long-term care costs legally before it is too late, and what happens to families who do not plan. I am Marcus Webb, and this is Benefits Decoded. Here is what we are covering today. What nursing home costs actually look like and why they destroy family wealth so quickly. How Medicaid works and what the 5-year lookback rule actually means. What Medicaid will and will not count as your assets. The strategies that legally protect your home and savings. What spousal protection rules exist for married couples. And your 30-day action plan to start protecting your assets right now. Before we get into the strategy, I want to tell you about a woman named Patricia. Patricia was a retired school principal in Ohio. She was 71 years old, sharp, active, and proud of the fact that she and her late husband had paid off their home and saved $420,000 over a 40-year career. She had 2 adult children, both working, and she assumed that if something happened to her, Medicaid would eventually step in and cover her nursing home costs. In 2019, Patricia was diagnosed with early-stage Alzheimer's disease. Her daughter Carol moved her into an assisted living facility to start. The cost was $4,800 per month, not covered by Medicare, not covered by her health insurance, out of pocket. 18 months later, as Patricia's condition progressed, she needed full nursing home memory care at $10,200 per month. Carol began the Medicaid application process. That is when the problems started. 3 years earlier, Patricia had given Carol $45,000 to help with a down payment on a house. She had also gifted each of her 2 grandchildren $10,000 for college. Total transfers in the prior 5 years, $65,000. Ohio's Medicaid penalty rate at the time was $8,000 per month, meaning the penalty divisor was $8,000. 65,000 divided by 8,000 equals 8.1 months of ineligibility. Even though Patricia had spent nearly all of her savings on care, Medicaid denied coverage for 8 months. The nursing home sent a notice. Pay or Patricia will be discharged. Carol had to come up with $82,000 more than 8 months of nursing home bills to cover the gap that the penalty created. She had to borrow against her own house. Patricia's total estate when she entered care was $420,000. When she passed away 2 years after Medicaid approval, the state of Ohio filed an estate recovery claim, a lien against her house, for the Medicaid benefits paid on her behalf during those 2 years. The house that Patricia spent 40 years paying off. Carol did not inherit the house. She inherited a Medicaid recovery claim. None of this needed to happen. With a $2,000 trust and a conversation 5 years earlier, Patricia could have protected her home and her savings, qualified for Medicaid without a penalty, and left something meaningful to her family. She did not know the rules, and the rules are designed to catch people who do not. Let us talk about what Medicaid actually is and how it works for long-term care. Medicaid is not Medicare. Medicare is the federal health insurance program for people over 65. Medicare covers nursing home costs for a very limited time, up to 100 days following a qualifying hospital stay of at least 3 days. After 100 days, Medicare pays nothing for long-term custodial care. Nothing. If your parent is in a nursing home for 2 years, Medicare covers the first 100 days under specific conditions and nothing after that. Medicaid is a joint federal and state program for people with limited income and limited assets. If you qualify financially, Medicaid pays for long-term nursing home care without limit. But the financial qualification requirements are strict, the application process is complex, and the look-back rule means that you cannot simply give everything away the day before you apply. To qualify for Medicaid long-term care in most states, a single person can have no more than $2,000 in countable assets. In some states, it is as low as $1,600. That means your savings, your CDs, your investments, and most property must be spent down to essentially nothing before Medicaid will pay. But not all assets are countable. Here is where it gets important. Certain assets are exempt from Medicaid's asset calculation. Your primary home is exempt from the asset limit while you are living. Medicaid cannot count it as an available asset and force you to sell it during your lifetime. However, the home is not protected from estate recovery after death. Your primary vehicle, one vehicle, is exempt. Your personal belongings and household goods are exempt. A small prepaid burial fund, in most states, up to $1,500 to $3,000, is exempt. And certain irrevocable trusts, if structured correctly and created more than 5 years before the Medicaid application, are exempt. The 5-year look-back rule works like this. When you apply for Medicaid, the government reviews every financial transaction you made in the previous 60 months, 5 years. Any transfer of assets for less than fair market value, a gift to your children, a transfer of your house to your grandchildren, a donation to charity above modest amounts is flagged. The government calculates a penalty period based on the total value of those transfers divided by the average monthly cost of nursing home care in your state. During the penalty period, Medicaid will not pay, even if you have no assets left. The cruelty of this rule is the timing. The penalty does not start when you make the transfer. It starts when you apply for Medicaid and would otherwise be eligible. So you can transfer your house to your kids, spend 5 years paying for your own care, run out of money completely, and then apply for Medicaid and still have a penalty period. Because the transfer happened within the look-back window, you have no money and no Medicaid. The nursing home either works out a hardship waiver or you get discharged. The penalty divisor varies by state. In 2025, it ranged from about $6,000 per month in low-cost states to over $13,000 per month in high-cost states. A $120,000 transfer in a state with a $10,000 penalty divisor means 12 months of Medicaid ineligibility. Now, let us talk about the strategies that actually protect your assets legally. Strategy 1, the Medicaid Asset Protection Trust. A Medicaid Asset Protection Trust, also called a MAPT, is an irrevocable trust that you transfer assets into, including your home, with the goal of putting those assets outside of Medicaid's reach after 5 years. Once assets have been in a properly drafted MAPT for 5 years, they are no longer countable for Medicaid purposes. You do not own them, you cannot take them back. But your children or other beneficiaries will receive them when you pass without estate recovery. Here is the key trade-off. Because the trust is irrevocable, you give up control. You cannot sell the house without the trustee's cooperation. You cannot take the money back if you change your mind. The assets belong to the trust. In exchange, after 5 years, they are fully protected. The right time to create a MAPT is when you are healthy, in your early to mid-60s, ideally before any signs of cognitive decline, and before you need care. People who wait until a diagnosis creates urgency often discover that 5 years is exactly the problem. The window closes and they have no protection. Cost to set up a MAPT, approximately $2,000 to $4,000 with an estate planning attorney experienced in Medicaid law. Potential protection, $300,000, $400,000, $500,000 or more in assets and your home. Strategy 2, the spend down with exempt asset purchases. If you need Medicaid and do not have a MAPT already in place, you can still reduce countable assets by spending down in ways Medicaid permits. Medicaid does not penalize spending on exempt purchases. You can pay off your mortgage and make the home more valuable a non-countable asset. You can prepay your funeral expenses up to the state limit. You can make repairs and improvements to your home. You can purchase a car if you do not have one. You can purchase certain irrevocable burial trusts. You can pay off legitimate debts. What you cannot do is give the money to your family. That triggers the penalty. The spend down strategy requires careful planning with a Medicaid attorney because the rules are state specific and the margin for error is significant. Strategy 3, the Medicaid compliant annuity. In certain circumstances, particularly for married couples, a Medicaid compliant single premium immediate annuity can convert a countable asset into an income stream. The well spouse, the community spouse, purchases an annuity that pays monthly income over their actuarial life expectancy. The lump sum is no longer a countable asset. The income stream is used for the community spouse's expenses. This is a complex strategy with specific IRS and state requirements and is not appropriate in every situation, but it is a legitimate tool that can protect hundreds of thousands of dollars for a surviving spouse. Strategy 4. Caregiver child exception. Federal Medicaid law contains an exception that allows you to transfer your home to a child who has lived with you and provided care for at least 2 years prior to your nursing home placement if that care delayed your institutionalization. This transfer is exempt from the 5-year lookback. It is called the caregiver child exception. To qualify, you need documentation letters from physicians, care logs, proof of residency, but for families where an adult child genuinely moved in and provided care, this exception can protect the family home entirely. Strategy 5, sibling exception. If a sibling already has an ownership interest in your home and has been living there for at least 1 year before you are institutionalized, you can transfer your interest in the home to that sibling without a Medicaid penalty. This exception is narrow and specific, but it is legitimate and it can protect the family home in the right circumstances. Now let us talk about spousal protections, because the rules for married couples are significantly more generous than for single individuals. When one spouse enters a nursing home, the other spouse, called the community spouse, is not required to impoverish themselves to qualify their ill spouse for Medicaid. Federal law protects a portion of the couple's assets for the community spouse under a rule called the Community Spouse Resource Allowance, or CSRA. In 2025, the CSRA allows the community spouse to keep up to $154,140 in countable assets. This number is adjusted annually for inflation. If the couple has $300,000 in savings, the community spouse keeps $154,000 and the rest must be spent down, or the ill spouse cannot qualify. The community spouse also keeps the home, one vehicle, and personal property. These are fully exempt. Additionally, the community spouse is entitled to a minimum monthly maintenance needs allowance, a guaranteed monthly income floor. In 2025, this ranged from $2,500 to $3,800 per month, depending on the state. If the community spouse's income is below this floor, a portion of the nursing home spouse's income can be diverted to the community spouse to bring them up to the allowance. These protections exist, but most families do not know about them and do not claim them correctly during the application process. A Medicaid planning attorney can help you claim every dollar you are entitled to keep. There is one more thing I need to tell you about that almost nobody talks about: Medicaid estate recovery. After a Medicaid recipient passes away, the state is required by federal law to seek reimbursement for the Medicaid benefits paid. This is called estate recovery. The state files a claim against the estate, typically against the deceased person's home, if they own one at death, to recoup what it paid for their care. If your home is in your name when you die and you receive Medicaid benefits, the state can place a lien on your home and require your estate to repay Medicaid before your heirs receive anything. In some states, estate recovery is aggressive and extends beyond just the probate estate to include assets passing through trusts. In other states, it is more limited. A Medicaid Asset Protection Trust, when structured correctly, removes your home from your estate before death. The home passes to your beneficiaries directly from the trust. There is nothing in your probate estate for the state to recover. This is one of the primary reasons MAPs exist. Now I want to give you your 30-day action plan. Step 1. Have an honest conversation about the numbers. If you are over 60 or you have a parent over 65, look at the cost of nursing home care in your state. Search the Genworth Cost of Care survey for your zip code. Know the actual number. Most people are shocked. Knowing the number makes the planning feel real and urgent. Step 2. Check the 5-year clock. If you are considering any form of Medicaid planning, start counting. 5 years from today is when any transfers you make now will clear the look-back window. Every year you wait is a year of protection you cannot get back. At 60, you likely have 5 years before care is needed. At 75, that clock looks very different. Step 3. Identify your countable assets. Make a list of everything you own. Separate it into 2 columns: exempt assets, like your home and car, and countable assets, like savings, CDs, and investments. The countable column is your Medicaid exposure. If you have $200,000 or more in countable assets and no long-term care plan, you need a conversation with an attorney. Step 4. Call a Medicaid planning attorney, not a general estate planning attorney. Medicaid law is hyperlocal, changes constantly, and is full of traps. The rules in Ohio are not the rules in Florida. The penalty divisor in California is different from Texas. You need someone who practices Medicaid planning in your specific state, knows the current rules, and has filed Medicaid applications recently. The National Academy of Elder Law Attorneys, or NALA, maintains a directory at nayla.org. Step 5. If you are a married couple and the ill spouse is already in a nursing home or likely to enter one soon, do not start spending down without speaking to a Medicaid attorney first. The Community Spouse Resource Allowance and the Monthly Maintenance Needs Allowance are rights you are entitled to claim. Many families spend tens of thousands of dollars they did not need to spend because they did not know about these protections. Step 6. If you are healthy and in your 60s, ask about a Medicaid Asset Protection Trust now. Not because you need nursing home care today, but because the 5-year clock starts only when the trust is funded. Every year of delay is a year of protection you cannot recover. Patricia did not know any of this. She had worked 40 years, paid off her home, saved responsibly, and assumed the system would take care of her. It did after it took nearly everything she had worked for. Her daughter Carol is still paying off the loan she took to cover Patricia's Medicaid penalty gap. You do not have to end up in that position. The rules exist, the strategies are legal, the planning window is open right now. What it requires is starting before you need it. If this episode helped you see something you had not seen before, I am asking you to share it with one person. A parent who thinks Medicare covers nursing home costs. A sibling who owns a house and assumes it is protected. A friend who does not know what the 5-year look-back rule means. Share this episode. It could save their family hundreds of thousands of dollars. If you have not subscribed to Benefits Decoded yet, please do. We release new episodes every week. And if you want us to cover a specific estate planning question, drop it in the comments below. I'm Marcus Webb. Thank you for watching Benefits Decoded. Protect your assets before the window closes.